The City Harvest Church trial resumed today with the defence making submissions for no case to answer. Kenneth Tan, senior counsel for John Lam, sought to show that there was no direct evidence that Lam was implicit in a plan to misappropriate church funds. Lam's accounting background saw his volunteer role in church affairs specific only to technical advice as an accountant, and that he had no or limited involvement in the strategic plans for the crossover project. In addition, there was no evidence at the material time of the alleged conspiracy that Lam had knowledge that the investments were sham. The burden falls on the prosecution to first prove that the investments were sham and that the accused were aware of that fact. Edwin Tong, acting for Kong Hee, stated in his submission that the prosecution sought to distance themselves from the evidence of their own witnesses and instead only relied on documentary evidence against Kong. Tong also showed evidence that a vast majority of documents the prosecution relied on in their written submission have not been addressed in the trial so far. Tong further states that evidence needs to prove that Kong intended to and agreed to commit the illegal act, not just that he intended to undertake the investment. Evidence brought to court so far has shown that Kong had explicitly invited the scrutiny of professionals, including auditors and lawyers, and that there was no intent of concealment as the auditors were aware of key transactions that made up the alleged sham transactions. Kanaan Ramesh, senior counsel for Sharon Tan, focused on the legislative history behind dominion for purpose of criminal breach of trust. Kanaan maintains that prosecution's case that Tan Yee Peng had dominion over CHC's assets and monies simply by reason of being a member of CHC's management board cannot stand. Membership on the board is not equivalent to dominion. While the board may collectively have dominion, it is not the same as saying that each member of the board had individual dominion over the church's assets. Kanaan also said that the prosecution led no evidence to show that Sharon Tan had knowledge that Ferner and Extron bonds transactions were bogus. It is his client's position that investments in and redemption of Ferner and Extron bonds were true and proper transactions. Michael Koo, acting for Chew Eng Han, questioned if the CAD had recorded any other evidence by witnesses who had not been called to court. This is especially relevant in the case of investments that require the approval of the church's management board prior to execution. To date, 7 out of 10 members of the board at that relevant time had not been called to court to give evidence regarding their state of mind when approval was given for investments to be carried out. If the investments had been approved by the management board, it cannot be said that Kong, Lam and Tan Yee Peng had committed criminal breach of trust when they did not have dominion over those funds. Senior counsel for Tan Yee Peng and Srinivasan continued the line of submission to state that none of the prosecution's 14 witnesses has supported the state's case that the purported investments were sham. Srinivasan maintains that since there was no wrongful gain, no apparent complainant, and no wrongful loss, there was no case to be answered. In addition, prosecution has not shown who did what and when in terms of the alleged conspiracy, but have instead depended on piecing together disparate emails and various communications to raise inferences of conspiracy and dishonest intent. Court resumes tomorrow with the last defense lawyer, senior counsel Andre Maniam, making his submissions of no case to answer on behalf of Serena Wee. For more information, log on to citynews.sg. I'm Andrea Lim for City News, Singapore.